Good afternoon, everyone. Happy Friday. My name is Alexis Alvarez Bartholomew. For those of you who don't know me, I am the Director of Statewide Training at Florida Legal Services. I'm very happy to be joining you here on this Friday to learn about Adoption 101, a topic that we don't really get a lot of education on in the legal aid and pro bono world. It's often, people in the private sphere doing this work, but, sometimes we touch it, sometimes it comes across, sometimes we want to do it pro bono. And I'm really hoping that the training that you have here today is going to give you some resources to do the best that you can if you do take on one of these cases. So before I move into introducing our speaker and we go into the content, I always want to give some housekeeping announcements. This training goes on today from 12 to 2. So it is a little bit of a longer one, but it's important because the information is so great and vast. So we're here from 12 to 2. However, this is being recorded. So if you have to hop back out, you have to go, do what you do in court or run back to a client, don't worry, you will receive a copy of the recording. The recording will come to you via Zoom in 24 hours. It's an automatic email, but I'm going to drop my email address into the chat. If you don't get that, don't worry, I'll send it to you. Second piece of housekeeping announcements, CLE credit. For those of you who are here to learn about adoption law or just here to get some CLE credits, I've got you both covered. This is approved by the Florida Bar for CLE credit, and I will announce that CLE code at the end of the session. It'll also come to you in a form of an email with that recording. And again, you can always reach out to me. I'm going to pop my email address into the chat. Third piece of housekeeping announcements, most important, are questions and answers. Please feel free to drop your questions into the chat or the Q&A. I will be here monitoring those questions and presenting them to our speaker here today. I always say we're in the virtual vortex. It feels wonky, but we are all connected in our passions and the work that we do as lawyers and this community. So don't be shy. Drop your questions in. I will make sure that they are heard. So moving into the more exciting stuff, today we have with us Elizabeth Berkowitz from the law offices of Elizabeth Berkowitz, PA. And I want to take a second and just tell you, the way that I found Elizabeth to do this training for us is I'm part of a listserv of Broward County attorneys, and there was some chatter about looking for the best adoption attorney that anybody knows. And the name that came up was Elizabeth Berkowitz. And I reached out and I said, please, are you willing to do this for legal aid? And Elizabeth was so passionate about what she does and the community she serves and helping other lawyers that she said, absolutely. So Elizabeth, I just thank you so much. I'm glad we're finally making this happen. All the hard work is on your end to do the education piece, but thank you for just signing on, joining us, and teaching us about this today.
Hi, everybody. So I always give a disclaimer at the beginning of these Zoom things that my technology experiences, as Alexis will tell you, are very lacking. So I'm going to ask everybody to bear with me. I know that we have been in the age of Zoom, but I'm old and I still get stuff mixed up. So thank you for having me. I am Elizabeth Berkowitz. I am the president for the Florida Adoption Council. The reason why I was so willing to lecture when Alexis reached out to me was simply because I am very passionate. I work very hard to make sure with my colleagues that adoption law is treated with a certain amount of respect and detail orientation because we are affecting the lives of children and families. So it is a topic that's very close to my heart. I have been practicing now in the area of adoption law for 19 years, and I've been an attorney for 24 years, so I know I probably really just aged myself, but that's okay. But what I want to just do is understand this. I know that Alexis mentioned in her introduction, well, this is actually a longer CLE than what you would normally have. And actually, my material that you're being provided with today is being condensed down from an 8-hour lecture. That's actually provided to people who are looking to specialize in the area of adoption in terms of the board certification classes and all that other stuff. So with that being said, please understand, and this is my disclaimer to this, is that this is an overview. This is the best that I can do for a 2-hour period. I am limited in terms of, giving you specific details. But I think that we're going to hit the high points of those today. So let's get started. I provided a PowerPoint, which I don't know if I believe it's been provided to all of you, but regardless, you should be able to see it on my screen. At least I'm hoping that you see it on my screen. And the initial question always is, and this is something I'm not willing to skip over when discussing adoption, is, well, why is it so important? Well, adoption law is an area of law that is so important because it is, and I'm sorry, I actually changed it on the wrong screen. So now I think you should be able to see it.
Yep, looks good.
Okay, great. Thank you. See, warned you about the technology problem. Not only are we dealing with children and families, which we know is very different than people's money and things like that, but adoption is the ever evolving area of law next to something like technology. Why? Well, it's different because technology affects it. You would think, how can it? Well, it does, because that's a mode of communication for people now. I think for many of us who, I think I'm called the Gen Z. I think is what I'm called now. The societal pressures have changed from the Gen X, the baby boomers. It's very different. So that actually affects adoption law. Our economy has a significant impact on adoption law, and you're going to learn why. But you're also dealing with things like expectation of privacy. And as many of you may know, wow, the drug market has really changed. I remember that the worst thing you could do was smoke pot when you went to high school in my days. I mean, that was a horrific thing. And now, not only do we have exposure to more drugs, we are having exposure to drugs that have not been medically tested. So what's a prime example? Well, we're dealing with things like fentanyl. Fentanyl was not something we had before to deal with, and the impact of fentanyl on babies and on pregnant women. But even going as far as things that you wouldn't think, there's a tea, I think it's called kava or something like, it's something like that. That even affects, like, it's not a drug, it's legal, but things like that do affect an adoption proceeding. So with that being said, you've got a lot of these external factors that come in, and the impact is severely so that it ends up impacting the law and how we proceed forward with adoption. So one of the things that's very normal for you to hear is no one should ever dabble in adoption. Okay. And I'm a strong believer in that. Okay. Adoption is not the area of law that you say, you know what? I took a CLE. I'm going to go ahead and I'm going to give it a shot. You never, ever want to do that. If you want to be exposed to adoption and you are going to work on an adoption case, I would really recommend that you find somebody who's either a board certified or a Florida Adoption Council attorney, because this is a very intricate area of law. It is not just family law. Sometimes I get very frustrated because it's like, yeah, it is divided up as a family law case, but adoption law is its own species. Okay. Now, with that being said, like I said, we're going to do some overviews. I want to be very clear. We need to make sure, if there's anything that you take away from this adoption CLE, it's number one, that not all child welfare laws are the same. When we're dealing with child welfare laws, many of us have worked in and understand the concept of Chapter 39. What I'm now asking you to do is look at two different areas of law, which cannot be treated the same because they are not the same. Chapter 39 cases, those are our dependency cases. A child has been removed by the state because of abandonment, abuse, or neglect. We know that ultimately the goal should be for a reunification of that family. We know that the state is the party in that case most times, okay? We know that we have these concepts of least restrictive means, right? Because we know that parenting is a constitutional right. So we have to protect that constitutional right to parent. So we have Chapter 39, which will guide us through the dependency system, okay? What is the other one? Chapter 63. Chapter 63 is what we're going to focus on today. That's the one that a lot of people, what they try and do is take the Chapter 39 areas of law, fact patterns, and pop it into 63. You don't get to do that, okay? 63 is treated completely differently. Chapter 63 is a private placement adoption. What does that mean? This child is not being removed because of abandonment, abuse, or neglect. It's a parent who's making a parenting decision to make sure that they bring a child into this world, or that they've already brought a child, and that they want somebody else to legally take over the role of being a parent. Okay. Now, so it's really, in essence, I always say to people, think of it two different ways. When you deal with, like, when we think about rights, parental rights in Chapter 39, well, parents surrender their rights. In a Chapter 63 case, parents consent to the termination of their parental rights. It's a choice that they're making. It's not something that's being taken away from them. Okay. In the state of Florida, because obviously that's all we're going to focus on today, the only way that you can facilitate these types of adoptions is if you have the consent of a consent required parent. And you're going to understand why I use this language later on, because we have different kinds of parents, but a consent required parent. Or there's only one other way to do this. You can prove that there's been abandonment. Okay. And again, we're going to talk about that in abandonment a little bit. But what we need to understand is there's no state involvement as it relates to a private placement. Okay. That doesn't make it any easier. If anything, it makes it a heck of a lot more difficult, because the scenarios are just as wide ranging. We know that in a 39 case, child had to be removed. Okay. The child's safety was potentially at issue. That's not what we have here. Okay. We know that under Florida law, there's one other thing that's a very important component. You have to understand that adoption law, when we're doing a Chapter 63 adoption, state is not involved, but an adoption entity must be involved. And we're going to define what an adoption entity is for you. But let me give you a little bit more background on adoption law. You need to understand that Chapter 63 adoption is statutory. We do not rely upon common law. The GS versus TB case, I don't think there's ever a brief that I have written that I haven't, doesn't matter what the topic is, whatever it's about, I have always made sure that I've started off with GS versus TB. It is what tells us you must follow the statutory guidelines. We know that in the dependency case, the state has the compelling interest in providing stable and permanent homes for children. And we've already discussed how there's a constitutional right to parent, but there's also a constitutional right to privacy, right? And we understand that. We understand that there's a constitutional right for anybody to retain custody of their child, okay, as full-fledged, I'm sorry, I have a spelling error, as a full-fledged right to parent. We know one thing that does keep Chapter 63 and Chapter 39 on the same page. There's really only one factor. And the factor is that the best interest of a child must always prevail. So it's always going to be the forefront of the concern. So I already taught you that the only way that you can terminate parental rights under Chapter 63 is if a consent required parent consents to the adoption and termination of parental rights, or if that person has abandoned the child, right? If the court makes a finding, they can't just stop there to do an adoption. Their next step, there has to be a next step. And the next step is that it is in this child's best interest. So that is the one thing that ties these two areas of law together. Okay. We know that, a lot of times in these statutes, we have like safeguards or initial statements provided by the legislature. I pulled the ones that I felt were most important to me. Number one, that the child is legally free for adoption. Well, we know that the child is legally free for adoption if a consent has been executed or if they have been abandoned. That there is a consent or a judgment terminating parental rights. So that means that if we don't have a termination of parental rights based upon consent, we have a termination of parental rights based upon abandonment. We know, and this is absolutely essential, that the required social studies are provided to the court and considered by the court. Well, what do I mean by social studies? Social studies means that a child cannot be placed, and we're going to talk about this a little bit later on, in a home without preliminary favorable home studies and post-placement supervision of that family. That court can't make a best interest decision unless it has those social studies. So we know to hit that second component, that best interest component, we need to make sure that that court has that. The next provision, this is one that is probably one of the most important ones as far as I'm concerned. All expenditures are reported to the court. We want to make sure that we are not having the buying and selling of children. And there are safeguards placed into the statute to make sure. Well, what are those statutory safeguards? Well, number one, that an adoption entity, a licensed entity, is facilitating the legal aspect of the adoption. And number two, that any financials involved, any expenditures, whether it went to the birth mother, whether it went to the attorney, anything must be reported to the court. Okay. Next thing, that the social and medical information concerning the child that is being placed for adoption will be provided to the prospective adoptive parent. Now, Alexis is on, so I'm going to assume that there's a question there.
There is a question. I can wait till the end. It's back about abandonment. I missed
Go ahead.
it.
It's okay.
You want me to ask it now or later?
Go ahead.
So the question in the chat and the Q&A is, in a Chapter 63 sort of case, if abandonment is somehow proven, why does this not automatically become abandonment as we understand it as the form of abuse under Chapter 39? How are the two abandonments different,
Excellent
defined,
question.
and customarily understood?
And now you'll see why my original lecture was 8 hours, because I got to talk to you about that. Unfortunately, if I get invited back, I can do a whole 2 hours based upon abandonment, believe it or not. But it's two totally different factors. It's evincing a parental responsibility. And I believe, if I'm not mistaken, we are going to address, are we going to address some abandonment? I think we are.
I think
at some point. I think it's on here. I believe that I am going to do it. Two very different sets of factors. So I hear exactly what you're saying, and that really is a fantastic question. But abandonment in of itself, if you compared the Chapter 39 factors that are to be considered and you compare the Chapter 63 factors, they're not the same. Now, about 4 years ago, so I don't know, when was COVID? Like COVID was 2021?
2020.
Okay, yeah, it was about that 3 or 4 years ago. This happened pre-COVID. We got together at that time. Ellen Berkowitz was working on the legislative level, and we were trying to get the abandonment. DCF wanted the abandonment to be more reflective of the Chapter 63. They did a little bit, but because there was some pushback, it was kind of where the statute's presently at. It's still not the same. Abandonment, for short, just to make this real quick, abandonment under Chapter 63 doesn't have specific factors. It goes to more of a generalized term of evincing parental responsibility. There is something, so let me give you an example. What's an abandonment factor? If a parent, while able to do so, does not provide any financial assistance. If a parent, while able to do so, doesn't provide assistance for medical. If a parent, while able to do so, fails to communicate with the child. So the factors are very different. And that's why I know it gets really hard, but that's why we teach this, to make sure everybody understands they're two different things. Okay. I hope I answered that. Again, please, I apologize, but this is an overview. So with that being said, if there's something that's just absolutely essential, is that we have to make sure, like I said, that we are doing strict statutory compliance, right? Because the fact is that strict statutory compliance is the only way that we can't afford. I think the best way to say it is this: we really can't afford for gray in adoption law. So we really have to be black and white. There are some points of the statute I'm not sure I necessarily agree with, and we'll talk about those, but it's the best way to make sure we don't have gray, all right? Because we're dealing with children's permanency. Now, with that being said, let me move forward. I gave you kind of like some key terminology, gave you a little bit on adoption law. Let's actually start to get into the meat of private practice and adoption. We know that the child must be legally free for adoption. We already addressed that. Here's the other thing. Written disclosure is provided to adoptive parents and the birth parent. By the way, the reason why it says and parent, we refer to them as the parent in the statute. by the adoption entity, okay? And a consent is obtained in compliance. We have to understand that there are exceptions in the statute that allow for different things to not be required if there's a step parent or relative adoption. And the simple answer to that is why? Well, because there's more of an understanding. For example, someone who's stepping into a step parent role, they don't need a home study. Why? Because the child's already residing in that home with them safely. There's still a best interest finding. It's not just, check the box and we get to go. But there are certain things that in step parent and relative adoptions that are not required. Another example that's not going to be required is because of the fact that all the parties know each other, you don't have that level of privacy required as you would in a unidentified adoption. So therefore, you can actually file the proceeding as one proceeding. We're going to learn that in adoptions, there's two proceedings. There's a termination of parental rights and there's an adoption proceeding. They're both have two separate files and case numbers. They travel together as sisters, okay? But the information that's in the termination of parental rights file is what deals with the birth parents. They have the right to privacy. What happens in the adoption file, which carries the home study of the family and all the documents relating to the actual adoption, that's in the adoption file. So we're protecting the rights of privacy. When you have a step parent and relative adoption, parties already know each other. So that's why we've taken out certain components, okay? We know, and I've already stated this to you, with the exception of an adoption by a step parent or relative, all adoptions require the use of an adoption entity. Let's talk about that word. What is an adoption entity? An adoption entity is defined as a person who, and I'm sorry, not a person. It's either one of two things. A licensed child placing agency, which is licensed by the Department of Children and Families, or it's an intermediary. An intermediary is defined as an attorney who is regulated by the Florida Bar. Why only these two can facilitate an adoption? Only these two can facilitate an adoption because they are licensed. They have somebody that they have to answer to. Let me go back to that number one adoption entity though. And I have to tell you this because a lot of people don't recognize this. That adoption entity, that's let's call it an agency, right? It's a licensed child placing facility. It's an agency licensed by the Department of Children and Families. Yes, they are an adoption entity that can facilitate an adoption. However, they do not maintain a law license. They must still hire an attorney to complete the legal documentation of an adoption. So for example, I facilitate my own adoptions, but I also have certain adoption agencies that are my clients. Now, did you hear what I said? Who's my client? My client is the agency. And we're going to talk about that a little bit later on. And I know I keep saying that, but I don't want to get too much caught up on it. But when a lot of times when people say to me, when adoptive parents call me, they say, well, what's the difference between if I work with you or I work with this big agency that's got a huge list of, mothers and they've got a huge network of marketing. Okay, that's fine. You can do that. But you become a client of the agency. You are not represented by legal counsel. You can seek separate legal counsel, but be prepared to pay for the agency and their attorney and your separate attorney. All right. It sounds like a lot, but that's what has to happen. Okay. Question?
Yeah, another
No,
question.
it's okay. That's great.
But again, it's kind of focused on chapter 39 and 63. Do you want to do it now or later?
Go ahead. I have no problems with it.
Awesome. The question is for a chapter 39 case where there's a termination of parental rights that's final. Sorry, my Q&A just, I have to try to scroll down and it's not letting me. Can a prospective parent switch to a chapter 36 adoption if DCF, for example, is not consenting to like an immigration status or considering a child is already with a prospective adoptive parent who completed all the steps, et cetera, et cetera. So can you switch?
From 39 to 63?
Yeah, if a case starts off as a 39, can it be switched to 63?
Well, okay, well, let me put it to you this way. You can only do it, first of all, let's be very clear about something. We know that under chapter 39 cases that it's not only the state that can file a petition for termination of parental rights. Don't forget that, okay? You can file, any person who has knowledge or is a person of interest can file in a 39 case. Here's what people don't understand. The ultimate adoption, let's say you have you get to the point where you have a termination of parental rights.
It's final.
Case moves over to 63 for the adoption proceeding anyway. Okay, but the termination of parental rights happened under the 39. So would you move over, I guess, if there's a pending 39 case? Well, that 39 case, you can't, the only way, and this is really going to go off topic, is if you file a motion to intervene on the 39 case because you have a consent, because it's the only way you can intervene on the 39 to remove jurisdiction from 39 to 63. That's the only way you can do it. And that's via intervention. And now there's a new presumption in intervention that if a child has been in care for more than 9 months, the presumption is the child has to stay. It's in the child's best interest, I should say, that the child stay where the child's at. Okay.
Wow. Wow. Interesting.
So now, why am I going through all this and trying to give you all the little details? Well, number one, because this is such a detailed area of law, and I'm letting you know how much work you've got to do before you even take on a case. Working an adoption case is so heavy before any legal filings can even be done. Okay, so you've got to walk in knowing that. You also need to know that there's huge liability involved with doing an adoption. I am actually proud to say that Monday I was in trial, in a trial that I never expected to be in. And I will tell you this, that I've spoken to all of I call them my predecessor dinosaurs, because I fear if I'm old, they're definitely older. No one has been able to get this, but I was able to get fees awarded to my birth mother to set aside a final judgment of adoption, okay, to be paid by the adoption entity, not the prospective adoptive parent, by the entity, okay, who tried to facilitate this adoption and basically stole this child from this young lady, okay? So be very aware, there's a huge financial, we know that you can get attorney fees if it's statutory, right? If there's a contract, if there's rules of procedure or bad faith, it's not easy to get attorney fees, right? Well, you need to know that there is a statutory provision that provides for your screw up. The other thing is you need to understand that it can go both ways, whether you represent a birth parent or an adoptive parent, okay? So it's not just one way. It's not just, oh, the birth mother tried to claim something and, the judge, said that, no, this is a termination of parental rights. She does freely and voluntarily. It can go the opposite way. It can go a birth parent pursuing an adoptive parent for having set something aside. There's also something that people don't understand. There's a provision in there, and we purposely did this because if we look at the Florida Bar v. Dove case, you're working with children. You have a different level of responsibility to the public, to the community, and to children. So guess what? We have a sanctionable conduct provision in our statute. And if this judge finds that you acted in bad faith, that your direct actions forced the judge to either set aside a consent for adoption or to overturn the judgment terminating parental rights, you're going to end up with a huge bar complaint, which is required to be reported by the judge. And the clerk actually has to submit that within 30 days. We take it really seriously. So I guess what I'm trying to tell you is don't mess around, okay? The basics before we begin, we actually already did this one. Who is the adoption entity? So you have to decide, you have to know what your position is. I'm an attorney, right? I've already said to you, I facilitate my own adoptions, which means I do my own matches between birth mother and adoptive parents. However, I have other clients who are adoption agencies. They are my client. I conduct the legal work, even though they are the acting adoption entity. Now, here's where it becomes an issue. Agencies, many times, they try and prepare all these legal documents, and then they try and send it to an attorney. No, you don't get to do that. So if you're ever looking that you're going to be representing an agency, please make sure you draft your own legal documents. Even if the facilitation doesn't mean the drafting of the legal documents. The facilitation is the match part, okay? It's the providing of the financials. I mean, so you need to really know, Emma, who is my client? Who am I representing? Because when I work on these agency cases, I'm going to tell you how many times these adoptive parents will call me to get a status. I'm like, I can't talk to you. I'm not trying to be rude, but you're not my client. So I can't talk to you. Okay. So it's very important for you to know, for your own purposes from the rules of professional conduct, what role am I playing in this? Now, this next slide, my favorite slide. Why? Because as far as I'm concerned, this next slide is the entire adoption law. What do I mean by this? What I mean by this is anytime I meet with an adoptive parent or a birth parent, I do nothing but review the Florida adoption disclosure. Because to me, this is a summary analysis of adoption law. Like we talked about how adoption falls under family law, right? Well, here's what I think is really interesting. And I've said this to my adoption colleagues before. You all are dumb. I'm sorry to say it like that. But if you all were smart, what you would do is you would follow the adoption bar. What did we do? We wrote this thing called the Florida Adoption Disclosure right into the statute. Language is exactly coming from the statute. And what we said was anybody involved in an adoption must execute this must execute and acknowledge this document. Why? Well, this is what we're doing. We're putting everybody on notice. These are what the laws are, so you can't try and argue otherwise. Think of it this way. I don't know what chapter it is for marital law because I won't touch it. I stay in my lane. But think about it. What about having a disclosure that says, this is what happens before somebody gets married? This is a disclosure that you have to sign. And this is what happens when you get married. And this is what happens when you get divorced. Now we have people actually thinking about, whoa, this is what I could lose, or this is what I'm going to be responsible for if there's going to be a divorce proceeding. These are what my rights are as it relates to the marital relationship. These are my responsibilities as it relates to the marital relationship. I'm like, I really think we would cut down on the divorce rate, but that's just me saying it. So with that being said, I'll move on from my tangent. The Florida Adoption Disclosure basically says anybody involved in an adoption, whether you're a birth parent, whether you're an adoptive parent, it doesn't matter. You must receive this document within 14 days of speaking to an adoption entity, and you must acknowledge it. Now, what happens with a lot of adoption entities? Many of them just basically say, here, and they give it to the birth parent, or here, they give it to the adoptive parent. Why would you do that? It would be, to me, this is what saves you as an adoption entity in terms of your liability involved in an adoption. Because anything that you could be responsible for that remotely could come back and bite you in the butt is covered by this disclosure. And failure to take the time, the 15 minutes it takes to explain this document, then you really shouldn't even be practicing law as far as I'm concerned, because it takes 15 minutes to get everybody on the same page, okay? Let's go through it. And I'm basically going to speak it to you the same way I would speak to one of my clients. State of Florida says everybody involved with an adoption must be placed on notice of these statutory requirements, okay? You're going to notice that some of them are more relative to adoptive parents. Some of them are more relative to birth parents. However, it's imperative that both sides understand the rights and responsibilities of the other side. Just like an auto accident, you wouldn't have one attorney facilitating everything, right? Let's go through this. First, number one says the name of the adoption entity and the telephone number. Well, why is that important? It's important because number one, we're telling everybody, we're putting everybody on notice. This is the name of the entity that will be considered the legal guardian of the child once the consents are signed and has facilitated the adoption, okay? we're putting everybody on notice of that. The next provision, it says an adoption entity can provide representation to prospective adoptive parents. Boom. I right there have put my birth mother on notice. I cannot legally represent you. Now, there is something that I have done, okay? If you'll notice on number 2, it says this means the adoption entity's attorney does not and cannot represent the birth parents. The adoption entity's fees and attorney fees are paid for by the prospective adoptive parents. That actually is not in the disclosure. I added that. Why? Because I think that's even more boom, letting my birth parent know from the minute that I'm starting to work with you, I cannot provide legal representation to you. All right. Now it's going to open the question of, does a birth parent receive legal counsel? Wait till we get to provision number 11. But my answer to that is yes. Okay. But we're right now knowing that even if this mom is communicating with me, working with me through her adoption plan, she's got to know I don't legally represent her. Okay. And this disclosure is telling her that. So, a lot of entities will say, well, I'll have them sign the Florida adoption disclosure right before they sign that consent for adoption. A, no, because the statute says you got to do it within 14 days. B, but more importantly, shouldn't she be on notice right away that you haven't been representing her this whole time? Yes. Now, there are cases where I represent a birth mother. This disclosure obviously is not relevant to those cases because in those cases, I'm stepping in the capacity as a birth mother representation. Now, the next one, with the exception of an adoption by a step parent or relative, the adoption entity cannot place the child in a home without a preliminary favorable home study. Now, that sounds like a paragraph that's mostly written for adoptive parents. Basically, what we're saying is not just anybody can adopt. You've got to go through the home study process before and be approved for an adoption before you can endeavor in this adoption process. Okay, this legal matching and all those things. You have to have that home study done. It's funny how a lot of times people will say to me, they don't understand. Well, yes, we're letting adoptive parents know you have a responsibility to go through this process, which is, by the way, an expensive and rigorous process. It is not the same as the Chapter 39 home study process. I'm very saddened to say that it's not even close to 39 in that it is so much more extreme. And this is just a personal disclaimer, I think it's disgusting that we put private placement adoptions have such more strict requirements. They have much more strict requirements than a 39 home study where you're in essence taking care of somebody else's child. Under 63, there's 3 to 4 times more I's and T's that have to be dotted. For example, Chapter 39, they're just going to check the Florida criminals background check. Well, under Chapter 63, you're required to comply with the Adam Walsh Act. That means you must have FBI clearances. We don't know if this family's coming from another country and maybe there was abuse against children in that other country. So we want criminal clearances that extend way beyond Florida. Also, what's part of the home study process? Well, education. There's an education component to it. There's no education component really required under 39, okay? Home visits. Yes, they do home visits in 39. They're not the same. The fire department comes in, checks to make sure that you have enough extinguishers. When my house had to be approved, I was like, I have extinguishers? And they're like, yes. And they even showed me where my extinguishers were. I didn't even know it. Okay. So it's a very different process. They have to provide letters of reference. They interview neighbors if necessary. Okay. There's a very different, it's a much more rigorous process to undergo a Chapter 63 home study than it is a Chapter 39. And I have a really big problem with that because I think that 39 should be more aggressive than 63. Because again, you're responsible for somebody else's kid who you're probably going to have to return. Now, while that paragraph sounds like it's really written for adoptive parents and we're putting them on notice, you have to go through this rigorous process. It's always excellent. I love being able to explain that paragraph to birth parents. Why? Because you would be surprised how many times they come in and they're very tense, right? Because this is, it's a lot of emotion about there. And as soon as I explain to them all the things that this prospective adoptive parent has to go through before they can even try to become an adoptive parent, it's like the shoulders go down. It's like, oh, really? They feel like I'm going to know that I'm picking a family that's not going to have criminal background, that's going to have these clearances, that's going to have this education. Isn't that the reason why they're placing their child for adoption? Because they want their child to have this better life and a safe, permanent, stable life. So therefore, I love to take the time to explain that paragraph to my birth parents, okay? Now, 4, 5, 6, and 7, you guys know how to read. I'm going to talk it out with you the way I like to teach it. I would like you to imagine, and I don't have a board, and because I'm not technology savvy, I'm going to ask you all to just draw a triangle on your paper. On the top of your paper, on the top triangle, on the top of the triangle, I'd like you to write the word BM. Then on one side of the triangle, I'd like you to write the letter F. And on opposite to that, I'd like you to write the word child. Okay? Paragraphs 4 through 7 address how we're going to make sure that everybody is protected under Florida law. Is Chapter 63 perfect? No. Is it so heading in the right direction? Absolutely, it's above that, okay? We've taken out a lot of gray, and you're going to understand how we've taken out that gray by doing this. Let's look at the top of your triangle. It says BM. BMs, let's write the word birth mother in. How are we going to protect that birth mother? Because we know that once upon a time, way before you and I were all born, and way before our parents were even born, it is true that river children were taken, placed in orphanages, and basically sold out to wealthier people. We know that. That's I teach an adoption law class. We know that we've begun there, okay? We also know that we progressed a little bit. All right, well, how did we progress? Well, we got to the point where at some point everybody said, oh, you know what? Let's make sure that a mother consents. So let's just have her sign documents that terminate her rights. Yeah, that is an improvement, but I don't know how much of an improvement it was when mothers were being forced to sign consents for adoption before they either gave birth or right when they gave birth. Yeah, I think we all know that doesn't pass the sniff test, right? Now, then we got to the point where we had what was called the Scarlet Letter Law. We're not going to go into that one. I would encourage you, if any of you are geeks like me, like my husband will tell you, biggest geek ever. I spend my nighttime when I can't sleep or I'm waiting up for my kids, I'm surfing Westlaw. That's what I do. I know it's really not something I should. My husband always says to me, don't admit that, in public, but I do. So looking into the Scarlet Letter Law is really neat to see how it evolved from the Scarlet Letter Law to where we are right now. What the present law is this: Mom, we're going to protect you. We are not going to allow you to sign any document that terminates your parental rights until 48 hours after your baby is born or until the time that you're going to be medically discharged from a hospital. Why? Because we want to protect her. She shouldn't be signing legal documents after she just had a C-section or she's just been given medications. We're not in the business of taking children from their mothers. That's not what adoption is. Adoption is about a different parenting plan that the mother is choosing for her child. And she has to have the ability to give birth, because you can't, I never understood this concept. How do you sign a document that terminates your rights to something that didn't exist pre-birth? If the child didn't exist, how did you give away that right? So now, but not only are we making sure that it's after the child's been born, but we're imposing a waiting period to protect her, to give her the opportunity to care for her child, feed her child, spend time with her child, do whatever she wants with her child, then to make a decision, do I want to do an adoption placement? Now, let's talk about that time thing in terms of 48 hours of medical discharge. Why? Where did we come up with those numbers? We didn't just pull them out of the hat. 48 hours used to be what Medicaid, if you were on Medicaid, you were given 48 hours in the hospital if you have a C-section. It's actually moved up to 72 hours. But for the most part, 48 hours is still what's being used for the Medicaid coverage guidelines. Like they'll give you up to 72 hours, but most health professionals do a discharge at 48 hours. Why do we say or medical discharge? Well, what happens if mama is a young lady, very healthy, she's a runner, she gives vaginal delivery, 24 hours pass, she's ready to go home. She doesn't need to wait. She doesn't want to wait in the hospital. She's ready to be discharged from the hospital. Well, that allows us, as long as we have the discharge paperwork, that allows us to take the consent before the 48 hours. Let's talk about the opposite scenario. What if mom had a very difficult pregnancy? This is one that we see often. Hemoglobin is very low. She's got to stay in the hospital for a week because she needs blood transfusions. As long as this mother is not medicated and she's of sound mind and she's able to make the decision, we can do the consent after 48 hours. We don't have to wait the week. All right. And that allows the baby to be discharged as well. So we give kind of two, let's call it two timelines for mom to sign her consent. Majority of times, what in reality happens? In reality, discharge is the same time as 48 hours. I mean, whether it's vaginal or whether it's C-section, I seem to find that it's generally the same. So with that being said, mom, we're going to protect you. We don't care if you've engaged in an adoption plan and you've been working with adoptive parents in this entity. You can't sign any document, though, that actually terminates your parental rights until 48 hours after baby is born or medical discharge. Now, let's go to the corner that said child. And you can also put in there /AP, adoptive parent. How are we going to protect that child's rights? Because the child does have rights. We want to make sure that we protect the child's right to permanency. What we're going to say is this: mom, the moment you sign your document that terminates your parental rights, it's immediately irrevocable and binding under Florida law. Florida law does not provide a grace period for you to change your mind. So now you understand even more the importance of that 48-hour period, because we're telling her now, not only do you get to sign it, you got to wait to sign the document, but once you sign that document, it's immediately irrevocable and binding. Now, excuse me, with that, all of that being said, if a child is above the age of 6 months old, so we have a baby, mom took her baby home, she tried to parent, thought everybody was going to help out, but the child's above 6 months old and she wants to do an adoption placement. We have a different standard. She is entitled to a 3 business day revocation period. Why? Well, because there's a presumption that bonding has already occurred within that first 6 months. When I'm doing an adoption and I'm facilitating, and it happens very often for children above the age of 6 months old, I will not place the child, though, with the prospective adoptive parent. The child will either stay with me or the child will go into cradle care for that 3 business days. Now, why do I keep emphasizing the word business? Chapter 63 is the only one, I believe, that allows this. Saturday is considered a business day. I know you're all thinking, huh? It is, because you get mail on Saturday. So it goes by the days that the Postal Service delivers mail. So we've protected mom. We said, mom, we're giving you, imposing a waiting period on you to make sure that you're making a decision as freely, voluntarily, you had time with your child to think about what you want to do. Child, we're going to protect your permanency, because we're going to say the moment, though, that mom does sign that document, you don't have to be worried about being removed from that, from your placement. So you'll have permanency. Now, let's go to that third corner, and it's called F. And I call it F for fathers. Why do I just, there's 2 different types of fathers, and I want to break it down better for you, okay? We need to protect dads too. The fact is that nothing bothers me more when somebody shortcuts a father out of the process. And I'm saddened to say that I've seen it on many of occasions. Fathers have rights, okay? Neither you nor me have the right to take away that person's parenting right because of their gender. Let's talk about who are the 2 fathers that we need to address in an adoption. One is a legal father, and number two is a putative father. Let's do legal first because that's easier. Legal is the person that the mother was married to at the time the child was conceived or born. Now, it does not matter. Let me just be very upfront about this. This is one of those parts of the law that people don't like, but this is what it is. If a mother is married and she has an extra relationship, extramarital relationship, and she knows that her husband is not the father, it does not matter. He is a legal father due to the marriage. And with that being said, he is what's called a consent required parent. Biology is not what's at issue. Why? Okay, I didn't write this law, so please don't shoot the messenger. The state of Florida believes in the concept of legitimacy. So if a child is born to an intact marriage, they're entitled to legitimacy. With that being said, we already said he's a consent required father, even if his name's not on the birth certificate, it doesn't matter. Now, again, it's conceived or born. So like I have a case right now, child was conceived during the marriage, but she's still pregnant and there's a divorce. Well, the child was still conceived during the marriage. With that being said, we already know he's a consent required father. For a consent required father, what we will do is he is allowed to execute a document pre-birth. We do not have to wait for him to execute a document after birth. It's not, we already have case law that it's not an equal protection argument because a woman carries the child. Legal father can sign a document pre-birth that says, I'm not admitting or denying I'm the father. I am in the intact marriage. I do not want parental responsibility for this child. It's basically an affidavit of non-paternity. Once we get that document executed by the legal father, we can proceed forward with the adoption. Okay. Let's say, this is a mom that we get at the last minute, or let's say the child's already been born. Well, we would have him sign a consent document. And there's a difference between an affidavit of non-paternity. Those are used pre-birth. Consents are used post-birth. Let's talk about the bigger guy, the bigger one, the putative father. Now we're going to have the opportunity to really delve into him a little bit more later on. And we're going to talk about the process, but because we're at the disclosure, I want to give you a little background on how we address the father issue. An unmarried possible biological father does not have the same rights as a legal father. Why? Well, because he's not legally married, so he's not providing legitimacy to the child. We know that the only way that you can prove genetics is with the DNA testing. State of Florida does not allow DNA testing for the purpose of an adoption, because that can go against the child's best interest. With that being said, we treat him differently than a legal father. He doesn't have automatic intact rights. Okay. He has to try and work towards his rights. Okay. And I'm going to walk you through the process, but what I want you to understand is that he will need to be served with documents. Specifically, how do I handle an unmarried biological father that's been identified to me? First thing I do is I contact him. I don't just send him legal paperwork, because my attitude is you can attract a lot more bees with honey. My mama raised me that kindness can go a long way. And you don't know what shoes this man is in. So why not just pick up the phone and call him and say, hey, this mother, let's name her, give her a name, Madonna, okay? Madonna is named you as a possible biological father. We're not saying you are, but you were saying you are possible because you guys obviously engaged in intercourse. Let me tell you what your rights and responsibilities are, because you're not treated the same as a legal father. You have to work towards getting rights. What does he have to do? Basically, he has two choices. We know he can either agree with the placement or he cannot agree with the placement. If he agrees with the placement and the attempt to do an adoption plan, he, like that legal father that we talked about beforehand, can sign an affidavit of non-paternity, which says, I don't admit or deny that I'm the father, but I'm in agreement with the adoption plan and I don't want parental responsibility. He doesn't have to deny biology. That plays zero role. Now, what if he says to me, I'm not going to cooperate with you and I don't agree with this and whatever. comes up. Okay, well, if he doesn't agree with me, that's fine, and he has a right. At that point in time, under Florida law, and as the paragraph 7 will tell you, I serve him with a document that's called a Notice of Intended Adoption Plan. The Notice of Intended Adoption Plan is exactly that. We're placing you on notice via personal service that you've been identified as a possible biological father to this child. In the eyes of the law, you're not a legal father, so you have to work towards obtaining a right to the child. So you have to do 3 things under Florida law, and you have 30 days from the date that you're personally served to do so. What are the 3 things? You must, number 1, file with the putative father registry. When I serve a father with a summons and with all the Notice of Intended Adoption Plan, I give them the pamphlet too. I don't play hide the ball. The idea isn't to play hide the ball. Serve them with the pamphlet that shows them how to register. The next one, a little bit more difficult. You must provide immediate financial support to the mother. A lot of guys here, they're like, wait, what? Why should I have to pay for? You're not paying for mom. You're paying for the child. You're helping her care for the child in utero. You're helping her have a place to live, have food. Okay. The third thing that a father must do within 30 days is you must file an affidavit with the court that says you're going to provide the court with, you're going to tell them what your parenting plan is, which is, in other words, how are you going to help parent this child? And number 2, that you're going to help pay for child support. A lot of guys hear that and like, wait, what? You're going to find many times there are men who are going to say, no, I'm not going to do anything. If they don't do the 3 acts that are required of them under Florida law, then the court will allow us to enter a default against the father and will allow us to proceed forward with the adoption without this person's consent because they didn't act to try and obtain rights to the child. Now, we're going to talk about other scenarios that we're going to get into a lot more detail, like what if there's multiple fathers? What if she can't identify the father? We're going to talk about those. But I just wanted to give you the lay of the land is we have a legal father, we have a unmarried potential biological father, and how we want to make sure that we protect everybody's rights. So now you can see why I did it in a triangle. I call it the triad because it's a statutory rights triad. We want to protect everybody's rights. Now I want to go, I want to go to number 6, which I didn't address with you. Sounds pretty generic and common sense. A consent for an adoption is not valid if it is obtained by fraud or duress. Duh. Okay, we know that. What are we going to do about that? How are we going to make sure that we comply? Because if I'm telling you this is the most important document that you have, how are we going to make sure that we use this information? Well, what we're going to do is before we allow the mother or the father to sign a document that terminates their parental rights, what should be done? I teach this in best practices for adoption attorneys all the time, and many of them don't want to do it. I don't know why, but I just basically leave my business card out there because then I tell them you're going to have to hire me to litigate your case based upon fraud or duress. Is you get around that entire problem is if you just take sworn testimony prior to having her sign a consent for adoption. End of story. You have a court reporter appear via Zoom, swear her in, ask her some questions just like a deposition. Make sure she's doing this freely and voluntarily. Make sure she knows what the word fraud means. Make sure she knows what the word duress is. Make sure that whoever she's identifying as a father or not identifying as a father is on the record. Okay? So now we can skip down to number 8. And the rest of these, I promise you, are easier, but I think that statutory triad was the most important one. I need to notify a birth parent that there are alternatives to adoption, including foster care, relative care, and community resources. Why? Well, because if she doesn't know, then that could be considered duress, right? She had no choice. So we're notifying them. We're notifying her right now. There are alternatives for you to do this. Number 9, a birth parent has the right to have a witness, to choose one of the 2 witnesses when executing the documents that terminate their parental rights. So whether it be an affidavit of non-paternity or a consent document, what is the statutory requirement is that number 1, we know there's a time that this document can't be signed before 48 hours or medical discharge. So when I have my notary sign it, I'm going to make sure that she puts a time in there to show that it's post 48 hours or post medical discharge. But I'm going to have a notary and I'm going to have 2 witnesses. This disclosure basically says mom or dad, whoever's going to sign, you get to choose one of the two witnesses. A lot of times I'll just say, choose both of them. I don't care, because it's just a witness to the signing. It's not witness to anything else. They can't testify as to anything else. They can only testify to the witnessing of the signature. Now, this is different. A witness, a notary cannot double as a witness. Again, we're taking another safeguard to make sure that we protect the adoption documents. So we're saying, notary, you can't double as a witness. So you have to have two separate witnesses and a notary. Next one. Oops, sorry. A birth parent under the age of 14 requires a parent or legal guardian. Now we changed the statutory requirement to now be saying that they are included in requiring being involved in the consent proceeding. So if you have a minor under the age of 14, one of those witnesses has to be a parent or a guardian that's appointed. I was telling Alexis before, you guys all got on, that I have a girl who just turned 12 years old, who's now pregnant. And it's a very sad situation. These cases are extremely difficult. I say that they're probably the hardest cases. Do they happen often? No, but they do happen. What is my recommendation for somebody as it relates to that provision? While I think it's wonderful to have the parent involved, I also think that it's got to be very difficult, maybe just me as a mom. Granted, I'm a mom of two boys, but it's got to be difficult as a mom to separate yourself from your child's legal decision. So a lot of times I ask the court to appoint a guardian ad litem. So you have somebody who doesn't have any stake in the fight, who can be a part of that mother, who doesn't have their own emotional baggage, if you will. A birth parent has the right to receive supportive counseling, whether by attorney, clergy, or social worker. Aha. Yes. And a birth parent is entitled to counsel, and I always encourage it. On all my adoptions, I would say 98% of them, I make sure that they have legal representation. Do they all need it? No. Do they all want it? No, they don't. But it protects your adoptive parent, okay? Especially if you're in a unique situation, we can talk about this later, where mom's refusing to identify the father because the statute doesn't require her to identify. It tells us the steps if she identifies, because we all know that we have a constitutional right to privacy, right? And that would violate her constitutional right to privacy. Last provision, and this is the one that generally gets to a lot of people, especially when I'm dealing with adoptive parents, is the payment of living or medical expenses does not in any way obligate a birth mother to place her child for adoption. What does that mean? That means that you can have a match that you're working with. Mom is started to develop a relationship with the family. They've been paying her living and medical expenses. And we're going to talk about what are those expenses that can be paid. I'm not sure if it's later on in the provision, but we're going to talk about, what documentation is required for disclosing all the expenses, because basically, just so you know, the provision isn't that we're buying a child, it's the payment of living or medical expenses that are directly related to the pregnancy. So in other words, this doesn't include expenses for diapers for every other kid in the house. No, it has to be related to mom. So if mom's not working and we have to pay rent, it's because we need to make sure that mom has housing, right? If mom has food stamps, but food stamps only go so far, okay, well, we can supplement it, but we have to be able to give the court disclosure as to why did we have to give more money towards food. And what we do is, in my practice, I actually, I filed a receipt with the court, and July 1, the laws is actually, we're having an amendment to it, which I don't disagree with it. And it should have been done this way anyway, that you have approval of your budget before you get to $5,000. A lot of courts don't want to entertain it. They're like, oh, we'll just do it at the end of the adoption. No, it should be approved beforehand, so that you're not in a position where you've spent all this money and then the court orders you to return money because they didn't think that it was an appropriate expense. What I want to say about this, though, is this, and this is the provision that a lot of people tend to forget. The payment of living or medical expenses is available, and it doesn't obligate that birth parent to place their child for adoption. However, The expenses are only allowable if a mom is unemployed, underemployed, or unemployable. And everybody seems to forget that provision. And so, and that makes no sense to me. You know, we don't need to, unfortunately, financials are a big component of why women are placing their children for adoption. And unfortunately, I'm sad to say that I feel a lot of colleagues use money as a way to pull women to their businesses. And it's not right at all. And they forget the position that, well, the mother has to be unemployed, underemployed, or unemployable. And you've got to show that. I want to address something else as it relates to the payment of living or medical expenses. Yes, if you are reading it right, what we're saying is an adoptive parent could be working with a birth mother 5 months. And if she changes her mind at the end of the pregnancy, she has the right to do so. And that's okay. You can't use that to make her do an adoption because that's duress. Now, that's a lay of the land. Let's talk about some immediate pitfalls that I always see initially. And these are ones that are so easy to avoid, and I don't understand why people don't do it. You're supposed to provide the written disclosure. We talked about that within 14 days. You don't wait until, like, I have been in a position where I've seen like agencies come in, and this is the first time a mom is seeing a Florida adoption disclosure. I walk out like, I don't want any part of this. No one's taking the time to review this with her. I don't want to represent that agency. Okay. You need a written acknowledgement. So in other words, it's not that they just saw it. You need to actually show that they've acknowledged it. Me personally, I make sure it's notarized. I want to make sure that there's a notary on there because I want to make sure that no one tries to say, well, that's not my signature. Okay. The disclosure is in substantially the same way. Here's what I'm saying to you. Don't take anything out of the disclosure. You can add to it a little bit like I did, because I think all I did was clarify it for somebody who may not have a higher level of education, but you can't remove anything from it. Okay. This case that I was talking to you about before, which I tried, they took sentences out of the Florida adoption disclosure and changed the wording of it. And I had never seen anything like that before. And the Florida bar is going to have a great time with that one because the judge had a great time with it. But you have 63085, which states that the failure to meet the requirements of certain specific things does not in any way constitute grounds for revocation. In other words, let's just say it has to materially affect it, and I think it's material failure of fundamental fairness in the administration of due process. So what would I qualify that by saying is that I would say this: what's a material doesn't affect the material failure. I had a case where I sent the documents to Mexico. The father was a Mexican pro soccer player, and his witnesses, he had witnesses sign, and the witness portion has to have their signature, their name printed underneath, and their address. Well, both of the men signed it. Both of the men printed their names, but the men didn't want to put their addresses. Why? Well, we understand that in the state of Florida, documents are sealed and confidential, but understand that they were, they're trying to protect themselves. They don't need, they are not going to trust or know that their information of where they reside is going to get out into the world. So I had to move the court to excuse it and say, well, listen, we didn't meet the requirement of putting the address down, but this is why. And it doesn't affect the fundamental fairness in terms of due process. So the court ruled on that, said, yeah, no, once they understood that these were professional soccer players, that they wanted to maintain their right to privacy, but they had to balance that with the fact that the father is entitled to choose his witness, then they couldn't tell him to pick another witness. He has that right. So the court, I think, made an excellent decision and said, yeah, we're going to waive the fact that that requirement had not been met. And just understand that I think that anytime you're going to have a case, as long as you have that Florida adoption disclosure, That document protects you in every way. Okay. Now, this next slide, it's a really big one. And I'm not going to go through it like in detail because then I'll never get through this. And you only have 50 minutes left with me. And I'm like not even halfway through, and I apologize for that. But basically what I want to talk to you about is, as it relates to this slide, I laid out for you that if I'm taking an adoption case to facilitate an adoption, what I would do on the birth mother side and what I would do on the adoptive parent side. Okay. And I even put in for you some statutory numbers to make life a little bit easier for you. But as you can see, that's a lot. And if I go through that, then you're going to have to tack on another hour or two. And now I see Alexis, so I'm going to let her talk.
Quick question. Came in about 3 minutes ago. I'm sorry I missed it. But it's about this topic. If the adoptive parents have paid for medical and living expenses for the biological mother, who then changes her mind about the adoption, does she have to reimburse the adoptive parents for the expense?
Excellent question. And I love when people ask it. And if you notice, I purposely don't address it because I always wait for somebody to ask it because I love that question. So I'm going to tell you what some people do, and I'm going to tell you what I would never do. There are agencies and attorneys that will have the birth mother sign an acknowledgement, basically an agreement that says that if I choose not to place my child for adoption, I will reimburse the family for the expenses that I received, whether it be living or medical. Now, you can do that, sure. But I'm just going to be a smart aleck and say this. First of all, how much lemon juice can you get out of a lemon? I mean, many people are already doing the placement because they don't have the money. You could get a lien. You're right. You can get a lien, or you can get a judgment on them, which lasts 20 years. But really, what are your chances of getting paid back, your client paid back? Here's my number two. And I have a colleague of mine who I just adore her and I look up to her, but this is the one thing we don't agree on because she makes her mom sign one. I think it's duress. I think it's a mom can come back and make the argument that I had to place my child for adoption. Otherwise, how was I going to pay back this money that I didn't have? And they're going to file a lawsuit against me. Now, let me tell you what her position is. Her position is, oh, I don't think it's duress because all you're doing is you're entering into another, it opens up the door to another legal proceeding, and you don't know what the outcome of that legal proceeding is going to be anyway. I'm just telling you, I don't like it. And I have had adoptive parents come to me and ask me if I will do that. And I tell them I'm not the right professional for them because I'm more focused on making sure I have an adoption that sticks. And to me, that, and I have not had a birth mother come and ask me to invalidate based upon that. But I think there's a huge grounds for it. I do. I can easily see making the argument, I didn't have the choice. I accepted all this money. As a matter of fact, in the case that we were referring to that I tried, this alleged entity put themselves out there as an agency, which was not licensed by the Department of Children and Families. And I couldn't believe it. This mother changed her mind before she even gave birth, but while in the hospital, she called the representatives of those people that she'd been working with and said, I really decided I don't think I can do a placement. She was like laboring, but hadn't given birth yet. And they actually told her, well, you already accepted living expenses. And they used that on her. And the judge was mortified. And, the question is, well, when does it become a he said, she said? Well, what stuck out really big for the judge was that the original plan was that this adoptive parent was supposed to be in the birthing suite during the birthing process so that they could cut the umbilical cord and be involved. As soon as that whole thing went down, that she couldn't change her mind because she received the money, she changed her birthing plan and said, I don't want them there. That stuck out huge to the court because that showed the court, wait a minute, she was having this feeling and she communicated that beforehand. So can you do it? Okay, you can do it. Would I recommend doing it? No. I mean, I'm just being honest with you. I want to teach you the best practices. So I would say no.
Thank you.
Next one. You've got everybody educated on adoption law. You got your adoptive parents have a home study. You got your birth mother. You got a match going on here. You got your birth mother who's getting prenatal care. What do I do? Let's go back and revisit the father, please. Why? Because there's other scenarios that we didn't get to address in the disclosure. Now, wow, that's a lot, right? So what I tried to do is break it down for you. These are just some of the scenarios. We know that we talked about the legal father. Now, when I want to address this because I think that this is really important. We had that huge case that, the Simmons v. Perkins case. And we know that you can't just claim, oh, there's a legal father, birth father, you're out of luck, checkmate. No, we know under Simmons v. Perkins that if a legal father is not taking care of their child, but that birth father has been showing and has been acting in the role of father, we can overcome the presumption. People forget it's a presumption. Presumptions can be overcome. Okay. So Simmons v. Perkins says, hey, don't ignore just because you got a legal father who signed a consent. Don't say, you know what? I'm done. I don't have to look for any more unmarried biological fathers. You sure as heck do. Okay. And again, because you don't know if any of those unmarried biological fathers can overcome the presumption. So I already talked to you about the way I handle birth fathers. Let's talk about other scenarios. Okay. We actually did this slide, but let's talk about, I like the next slide. It's going to give you other birth father issues. What if we have more than one birth father? Happens all the time. Okay. Happens all the time. And that's okay. We're going to do the exact same thing with identified possible biological fathers. Same thing I did with dad A, I'm going to do with dad B. Now, what if mom says, I can't identify the father. It was a one-night stand. Well, I always go into my inquiry, which says, well, why can't you identify him? Well, I was drinking, Elizabeth. I can't, it was a one night, it was nothing. Okay. The statute says specifically, and it says, by virtue of the fact that a man has engaged in a relationship with a woman, he's deemed to be on notice of the pregnancy and the possible placement of the child. If a birth mother fails to identify the unmarried biological father to the adoption entity, now here's the key word, by the date she signs her consent for adoption, the unmarried biological father's claims that he did not have actual notice of the adoption is not a defense. So we are relying upon that mother. So now do you see another purpose for that consent proceeding that we talked about with getting sworn testimony? Because that's the last line that I have to cross. It says, if she's saying that there's no identifiable father, I want to make sure that I've got it on the record. Yes, she's still saying that there's no father. What if she says to me, Elizabeth, I know his name is Michael, and Michael lives in Fort Lauderdale. Okay, do you have any other information on him? Whatever information she gives me, let's just say she's able to provide me with, well, this is his telephone number. This is his Facebook page. At that point in time, I am then required to do an affidavit of diligent search to locate him. Now, there are going to be times where we don't have enough information to locate him. There's many times where my affidavit of diligent search comes back and it says, there's no way based upon this minimal amount of information that he's locatable. Again, what do? On the day that I have my mom sign her consent, I renew that information with her. Do you have any other information? If there's no other information, again, the responsibility of the adoption entity has ended. Let's talk about if mom has identified a father and he is located, we were able to locate him. Great. I'm going to be honest with you. I'm always the one who, a lot of times moms will come to you and initially, there's some trust issues and you have to build up that level of trust. And what I will say to a mom is, she may not want to disclose the father initially, but as she gets to warm up, why is it important for her to try and encourage her to identify the father? Because let's remember that a child's genetics come from two people. And don't you want the adoptive parents to have all the information that they can regarding that person? What if, this is the next scenario. Mom says to me, Elizabeth, I'm not going to identify this father. Not going to do it. He's a bad man. I'm in fear of my life, and I'm not going to identify him. What's the first thing I do? I make sure she has an attorney. I immediately make sure that she has legal counsel so that she can invoke her right to a privacy. I can't force her. The statute doesn't require her to do a disclosure. So I can't require her to do so. Okay. Now, if also I go to the court and I say to the court, I file a motion, I say, Your Honor, this child was conceived as a result of a sexual battery, and it lists the specific, things that fall in, like, I think it's lewd acts perpetrated on a minor or any of those types of child. Then the court will excuse us from having to notify a father. Okay. Let's talk about, go back. Let's talk about the constructive father. The constructive service. Legal fathers, let's say we can't locate them. We can't locate them. She's been separated from him for 6-7 years. They haven't seen each other, but they never got a divorce. I am required to do constructive service, and which basically means, and I can't locate the guy. I have to do constructive service of the last place I believe that he lived. And in my service, in my DBR notification, it will say the name of the notice of hearing date, so that I put them on notice of, this is the date for a potential hearing for you to appear. Now, I think there are some questions, so I'm going to wait for Alexis to come in, but I want to mention in the bold, it is 100% correct. I don't care what type of an adoption you're doing, step parent, relative, anything. You always must request a putative father registry certificate. Please, always. There's never a reason to not do so. Alexis, I think there are questions. I think I'm getting better.
They are, but they're kind of background. Someone asked if we can get copies of the slides and the handouts, which
okay.
I think you can send me later on, right afterwards.
Absolutely, yeah.
And then another one's about a certificate of attendance, so I'll handle that.
Oh, okay. Sorry. I always get nervous that I'm not answering somebody's questions.
Yeah, absolutely. Thank you.
I know that slide 11 especially was a lot of information, and you're better off just going through it yourself.
Absolutely.
Now, let's talk about red alerts that deal with father issues, because I do think it's important enough that we spend some more time on this issue. If a birth father fails to file with the putative father registry, he is barred from filing a paternity claim. It happens all the time. I'll have a father that out of nowhere, he'll pop up and file a paternity claim. Can't do it. Okay. Fraudulent representation is not a defense to compliance with the requirements of 63. So in other words, I've had a father say, well, she knew where I was, or I've been, wherever. Well, where have you been? If you haven't helped her out, can't do it. It says the court shall enter a default for putative fathers. Okay. That's when I say by default provision, what I mean by that is that means that the 30 days had expired. Now, a lot of people ask me, generally this pops up a question, so I'll just answer it so we don't have to get Alexis back on. The question is, well, Elizabeth, what if they've done one of the two things, or they've done two of the three things, or what if he files on day 31? Day 30, and by day 30, you're cut off. So you don't get to come back a week later and send in money and try and do it. And you don't get to do only one of the three things. You must do all three things. We talked about 062. Any man pre-birth can sign an affidavit of non-paternity, which means a legal father as well. I tried a case, and that was one of the issues, is can a legal father sign an affidavit of non-paternity? And the answer is absolutely he can. Okay. If he had knowledge of the pregnancy, that he has had paid a fair and reasonable amount of the living and medical expenses incurred in connection with the pregnancy and the child's birth. Okay. Now, why did I put this in there? It says in accordance with his financial ability. So I think we should recognize that, And it's not abated if the birth mother is already receiving support from a third party. What is that? When is that applicable? Well, I'll tell you when that's applicable. Let's say you get a last minute placement. Girls, you got called in, baby's here, okay? Now you got to go back and you've got to address, you still, if you have a father who's been, that you have to serve a notice of intended adoption plan on, you got to go back and you got to do all those things, dot all those I's, cross those T's. Now what happens? Let's say this child was placed in a home with adoptive parents, prospective adoptive parents, and this birth father shows up, and he can't use the argument then, well, I didn't have to pay anything towards the child because the child's receiving care by the prospective adoptive parent. No, courts don't allow it. We have specific case law on point with that. Okay. Now, most important thing, I always laugh, to be honest with you. I remember the first time, and I know it's been a gazillion years, that I went into a dependency courtroom. It's so different, right? It was like deer in the headlights, right? And it's so funny. I always tell people, I'm like, the family court system is so different than the dependency system. And you shouldn't walk into one or the other without being prepared. Very different. You walk into a dependency courtroom, please know the juvenile rules of procedure will govern. You walk into an adoption courtroom, it's the family rules of procedure that will govern. Okay. Other thing, know this. I mentioned it before. You're always going to have two separate cases. Why? Well, we talked about the confidentiality issue, which is we want to make sure that the TPR case has its stuff and that the adoption documents are separated out and the cases will just travel together. Now, a lot of people do ask this question, and I put it in there. The notice of intended adoption plan, that goes to the termination of parental rights side. Okay. But the petition to approve the placement and the DEC action that relates to the financials of the adoption go into the adoption side of the case. All right. I feel like, I don't know if I'm behind, but I feel like I am. So sorry. I'll try and go real fast now. TPR case. I gave you basically a list of making sure things that you better make sure you have in your pleading. Okay. It's just, these are things that these are what you need to make sure you have pled in your proceeding, in your TPR case. I am going to do this next one's a great one. It's going to tell you, these are the documents I need to file. Okay. I gave you a list. I'm going to do the same thing here for the next one. What does my adoption pleading need to look like? And these are the documents that I better make sure my adoption file. Okay. Now, successful adoption is completely dependent to me on the formal consent proceeding. I think that it is imperative to have a court reporter and have sworn testimony prior to a parent signing consent for adoption. Making sure that you have these two witnesses that are separate from the notary. Make sure that if possible, you can get your birth mother, have legal representation, and you want to make sure that there's absolutely no fraud or duress. What I want to talk to you about is I want to spend a little bit of time on this because I do think that this is an important slide. Let's talk about the declaratory statement. When is a declaratory statement needed? Why? What's it for? The declaratory statement is a part of the adoption file, and I'm going to teach it to you now as the way it's going to be of July 1. Approval of the court is required before certain amounts of money are paid out in the case. So for example, $5,000 in legal fees, $800 in court costs, $5,000 in the living and medical expenses. What it means is, why are we doing this? We're asking the court to approve the fees that are provided to the birth mother so that we're making sure that we're not engaging in the buying and selling of children, right? Now, if you look at where it says petition for approval, basically what I'm doing is I'm filing a budget with the court, and I'm asking the court, please approve this budget, all right? And a lot of times you should ask for approval of that budget before you get close to the budget lines, all right? Again, reasonable expenses of the birth mother, not her boyfriend, her roommate, her 4 children, or her dog, okay? Unable to pay due to unemployment, underemployment, or disability. Such expenses are allowable up to 6 weeks postpartum. Why? Well, let's understand that it takes time for women to go back to work. And we use the American Obstetric and Gynecological guidelines that tell us 6 weeks is generally what a woman needs to recover. When is it that we see an expense that comes up that wasn't originally planned on? Well, mom had to bring in a babysitter so she could run to the hospital to deliver this baby. The court generally will approve something like that. You have to understand this. Adoption is very fact specific. I mean, I'm sure that you're seeing that. Everything that I can tell you these things in a generic sense, but adoption law is very fact specific. There's no like one set of documents that I have. I may have a framework, but I'm always changing my documents and none of my cases are ever the same. Like I remember when I first started being an attorney, when I was doing litigation, I used to do malpractice and auto accidents and all that type of stuff. And what I remember is like, I put all the auto accidents in one pile. I put my malpractice in another. It was like, I could group them up. In adoption law, you don't get to do that because there's no case that's alike the other one because there's generally no facts that are similar. Okay. In terms of, let's address the legal or other fees. What are or other fees? That could be counseling fees. Legal fees, just so you know, they're either going to be produced to the court either in an hourly or a flat fee. Majority of time, you're going to find that adoption entities act on a flat fee. Why? Well, flat fee actually works out better for a client. All right. When you file your deck action, where you're asking the court to approve your expenses, you're also going to file an affidavit of expenses. You're going to file an affidavit that says this is what you plan to spend. And then at the end of your case, when you're going to show the court this is the final accounting of the case, you're going to file an accounting that shows this is what has been spent. All right. It's got to be itemized in detail. Again, I'm in Palm Beach County and I'm not really sure where most of the audience is from, but I know that a lot of my colleagues get mad at me because I just thought it was easier besides listing it in the petition. I just actually started attaching the receipt. So like, even if I took a mom for, let's say I was going to go have a match meeting or set up and she had a Coke, I attached the $1.19 receipt to it. Right. And my colleagues got really mad at me. They're like, you didn't have to attach a receipt. I'm like, well, it's just easier that way. That was my way of showing the court. So now a lot of the courts, well, actually, under the new statutory requirement, they're going to require receipts, which I think is a great thing. I guess the question really becomes, at what point does the court have discretion to play a role as to what is reasonable and what is not? You know, I have to be honest with you. The way I look at that is every circuit is different, and it saddens me that my particular circuit doesn't view the understanding that these are women that, for example, housing. We don't get to control the price of housing. I don't know about you all, but the price of housing is out of control. So when you get a huge birth mother bill that your clients had to incur, majority of it is housing. What happens also is that you may have a mom who can't secure permanent housing, right? And she's got to live in one of those extended stays. Those are expensive. Those are over like $2,000 a month, but you got to provide housing for your mom. And if she's got a felony, you know, she's not just getting into any place to live. So trying to seek out housing, affordable housing, is another question. Trying to locate housing in and of itself is a problem. Now, when you start attaching the price of that onto it, it's a totally different animal. And I think it's imperative that all of us who are going to be doing this in our circuits take the time to explain this to the court. You know, why are these bills so high? Well, cost of living is really, really high. Okay. Now, I'm going to talk to you about my favorite thing very briefly. And the reason why I'm going to say briefly is because if I go real far with this, then I can honestly tell you that you'll never get out of here, because I can talk about contested adoptions for about 12 hours straight. There are a limited amount of us that do contested adoptions that I say that there is no more than 10 attorneys in this state that are qualified to do contested adoptions. I know you're going to say, Elizabeth, that's really obnoxious of you to say, but I'm telling you, it's a very different component. is doing contested adoptions. Me personally, when I jump into a contested case, for me, it's like you have to throw yourself in. It's not like when I did litigation for personal injury. This is just very different because you're definitely dealing with people's lives, but it's a chess game. And the idea is to seek permanency as quickly as possible because we're dealing with children. Contested adoptions involve a huge amount of emotion. It's different than I think it's different than any other type of trial. I think you're dealing with a set of facts always, that there's just a huge emotional level on both sides. Okay. So let's think of it this way. You've got, let's say, God forbid, you had an auto accident where you have a death. Okay. Well, generally you've got one side that's got emotion that's invested. In these cases, you've got two sides with emotion invested. So it's very difficult. Remember that the Florida Family Rules of Procedure are what govern. They are all bench trials. The state of Florida, all of our cases are sealed and confidential pursuant to the statutory requirements, which means no one can access the court file, which means we can't have a jury. So they are all bench trials, which, as far as I'm concerned, bench trials are so much harder than jury trials. Why? Because you can't get away with stuff. Judges know the rules of procedure. They know the rules of evidence. Now, abandonment, setting aside final judgments, those are the two instances when you have contested adoptions, when you're dealing with either an abandonment issue or you're trying to set aside something. We need to also remember that birth parents are entitled to court-appointed counsel. All right. So, especially when you're dealing with the abandonment cases, you got to make sure you always want to confer with an experienced attorney. Don't ever. I think that one of my things that I have the hardest time with is when I have to step into a case that somebody screwed up because they made it so much worse than if they had just conferred with a proper litigation adoption attorney. And it has taken the clients through a lot of money, but more importantly, it's delayed the permanency of the child. And more importantly than that, it's messed with everybody's emotions. Okay. We talked about private versus state. Let's see, that's just my reminder type of thing. Let's talk about best practices. Again, making sure that you're always conferring with an experienced attorney. Confidentiality, don't minimize that. So let me give you an example. Why do people understand, well, why is that such a big deal? If I'm talking to a birth father on the phone and he's asking me questions, I don't get to tell him, no, listen, you're the only dad. I don't get to tell him who the other dads are. I don't even get to tell him that there are other dads. So every little step in through your process, you have to keep the confidentiality requirement in the back of your head. Okay. You're going to find that many times your record keeping is so important in adoption law, because remember, once that adoption is sealed, no one has access to it. So you want to be very meticulous about your record keeping. Pitfalls, make sure you're always having regular meetings with your client. I think that's in every case, no matter what area of law you plan in. But I think that it's even more important in adoption because, again, these people are going through an emotional journey. This is a key for me. Keep your pleadings updated. You know, it's so funny because, yes, like I said, we have like a certain amount of documents and that I use as a skeleton. I am constantly updating my documents. I don't care. It doesn't matter to me in terms of, it's about me being updated because case law changes every year. So there might be a word. And here's the other thing, by me doing contested adoption cases, I'm learning and I'm like, oh, you know what? If I had that one sentence into that affidavit, that will never happen. You know, things, I think the thing with adoption laws is that the things you don't ever think can happen, happen. So you always got to be prepared and you got to be willing to be flexible and be willing to constantly keep work on top of being a better attorney, being a better record keeper, being better at your pleadings. Create pleadings that aren't required but are preventative. Well, what do I mean by that? Well, like there are documents that I've created that are definitely not required by the court. Let me give you an example. I create a document. It's called a waiver of confidentiality for my birth mother to sign. Because remember, all of her documents are confidential. So when I give the adoptive parents the medical records, I have to redact the name, the social security number. Well, number one, I have the mom sign a waiver of confidentiality that she's going to allow me to release her name on her medical records. There's the other thing that's another preventative as it relates to confidentiality. Let's say, because remember we said it's a sealed proceeding, so no one can access the court file. Let's say the child turns the age 18 and the child is wanting to look for the birth parent. Do you want me as the adoption entity to provide the birth mother, to provide your name? Do you want to give the court authority to release the court file? Because then they can do it. So these are not required documents, but they're preventative in nature. What's another one? An affidavit of financial need. When we talked about those expenses, remember we talked about this is a mom who has to prove that she's unemployed, underemployed, or unemployable. Well, have her sign an affidavit of financial need so that the court recognizes, yes, this is somebody who needs expenses, so that that issue doesn't come up down the road. What if she's insistent, I don't want an attorney? Well, have her sign a waiver of legal counsel. Make sure you dot all I's and cross all your T's. Waiver of service of pleadings and notice. I think that's a very important one. How about, I've had a case where let's say the mom was Hispanic and she wanted to only do it she wanted to do everything in Spanish. I'm sorry, in English, because she was insistent. No, my English is good enough. Well, I had her sign a waiver that she specifically was choosing for me to proceed forward in English without a Spanish translator, because I wanted to make sure that I covered that base. Making sure that everybody understands the documents that they're going to be signing. I think it's very important to communicate all possible scenarios to everybody. And anytime, like I said, because you're dealing with fact-specific cases, you can anticipate something, prep for it. If you're going to represent an agency, educate your agencies on how they can do better, because there are a lot of agencies that will say to you, you're going to use our documents. And my first answer to you is that's a red flag right there. Because guess what? You still have legal liability as an officer of the court to make sure that things are right. And you can't rely upon non-attorneys drafting your documents. So please, please, I would encourage you to not fall into that trap of, oh, this is an easy client because I just have to I just have to file the documents on behalf of the adoption entity. That's not an easy trap. It's not something you want to engage in. Now, let me give you the last slide. See, I actually made it through those slides pretty quickly because I was concerned that I was going to be late, and I know what it feels like to not want to be late. So I'm going to make sure that you guys are given the opportunity to ask questions. I just want to emphasize this. This area of law is very unique. If you had a tax problem, you know yourself, you wouldn't be going to a general practice attorney. You know that you would go to a proper tax attorney. And I'm asking you to treat the specialized area of law with the same level. It's different. It is so intricate that it's crazy how intricate it is, which is probably why we have our board certification for it, but it's not impossible. So if it's something that you want to engage in doing, I'm not discouraging you at all. Please do it, but take the proper steps before you even engage in it. Become a member of the Florida Adoption Council. Hook yourself up. We have a mentoring program so that we'll assign you an adoption attorney that will co-counsel with you and your initial adoptions. And that is the greatest way to get started in doing this. Everybody assumes, what frustrates me is that everybody assumes that adoption law is happy law, but they don't understand how many things can go wrong. I want to end with one last thing before I pass it over. Last Friday, I took an ethics CLE, and probably one of the best ethics CLE I've ever taken. It was given by a professor in Texas who teaches adoption law, and it wasn't about Florida specific, but it was just in general dealing with adoptions. And what she said was absolutely 100% right. When you think about it, adoption is, I got to think about what the words were. Hold on one second, because this was great. She said, adoptive parents in an adoption are maybe the fifth or sixth best person to raise that child. Okay. Think about that. Well, why? Well, we always know that it's in a child's best interest if they can stay with their birth parent, right? There's no question that it's in a child's best interest if the child can stay with their birth parent. The next best option is if a family member can adopt this child, take care of this child, so the child stays within its family unit, right? But then what happens to 3 and 4? Well, let's say you have a child who's African American. Ideally, well, you want the child to be brought up in its culture, or if the child's of Native American descent or of Asian descent, you want them to be brought up in their culture. So that's maybe the next third person. And then who's the next fourth person? So by the time you get to the process where you have a client, you have to realize you are, yes, representing this client, but that's not what the initial best interest of that child would have been. And you have to treat the process with significantly more level of, I don't know, I'm not exactly sure what the word is I even want to, you have to treat this level of adoption as with such specificity, because at the end of the day, we do want what's in the best interest of these kids. And that's all I got. And not only did I do that, I ended it, I think, 4 minutes early.
Amazing, amazing. Elizabeth, I've been like captivated listening to you.
Tell my
Um,
kids that.
Honestly, I just like, I can't even imagine you in court. You are probably incredible and fierce, and your clients are so, so lucky to have you. Um, no other questions that came in through the chat. Thank you, definitely a thank you. And I think others coming forward as well. I don't have any additional questions. I totally see what you mean about all of the stuff that you could have gone into. And it's incredible. You've sort of, I guess, in a way, opened my eyes to all of the nuances within adoption law practice, which I think I even wrote off as just, okay, that's just another type of law. Like, no, it is, the way that you talk about it, it's like a breathing, living, like organism within our body of law. And I'm just in awe listening to you.
Oh, thank you.
Let me see. So
I wish
yeah,
my
again,
kids felt that way. I even wish my husband felt that way.
I hear you there.
I mean, I that's why I always end with this slide, because like, it's like I put everybody to sleep. So
Yeah, no, you did not. It was captivating, I'll tell you. And so I do want to let folks know I did drop the CLE code in the chat. I'm on a different computer than I normally am, so it's hard for me to type things in. But so it's 240565, N as in Nancy. Again, I'm looking over here to double check. 240565, N as in Nancy. And this gets you 2 general CLE credits and 2 certification credits in adoption law. So quickly, Elizabeth, something did come up that I think actually is a great question for you. Are there any trends or pitfalls you see with relative adoptions?
yeah, great question. So you know what? Okay, let me tell you what the pitfall is. The biggest one is, and this is one that I get a lot. You have a relative adoption only goes to the third bloodline of consanguinity. And here's what happens. Everybody's like family member, let's say, wants to step up. Oh, that's my aunt. That's my uncle. But by the time you do the research, you're like, wait a second. Just because they call them aunt or uncle this, they're not. So you've got to make sure you're within that third bloodline of consanguinity. I had a case where a family law attorney, oh my God, they feared, oh, this is a relative, so they don't need a home study. Baby was born, they take the baby home, and the judge kicked it back and said, wait a second, where's the relationship here? And the attorney's like, well, it's an aunt, it's an uncle. And I ended up finding out, no, so what did we have to do? We actually, it was not pretty. We had to I made them remove the child, even though this was such a distant family that they needed to get a home study. And I wasn't going to act as the adoption entity until they had a home study. So that's a huge pitfall that you want to be careful with. Here's the other thing, and I hate to say this, but I feel like it really is annoying, because I feel like grandparents and relatives, like step-parent adoptions, they should be able to file it on their own. It should be easy enough of a process, But what happens is they try and do it by themselves and they keep getting it kicked back, keep getting it kicked back. This client that I met with yesterday told me it took him 2 years to do a step parent adoption. I'm like, why? I'm like, did the child's biological father not agree? Because that's the only thing I could think of. Like, no, there is no child's biological father that was identifiable. There was none on the birth certificate that was named. And I'm like, well, how did it take you 2 years? They're like, because we did it on our own.
Yeah. Yeah. And actually you touched on a question that came into the Q&A. It was about grandparent adoptions and it asked, what's the main difference when it's a grandparent adoption?
You know what? Think of grandparents are older. Here's what I would say to you. If you're working with a grandparent adoption though, and thank you for bringing that up because that's actually something, it brings up a great learning component. We know that grandparents are generally older, right? I always make sure when I'm going to do a grandparent adoption, make sure that there is somebody that has been assigned, that they've chosen somebody via will to be a guardian or something of the child, should God forbid something happen to them. Because you want to make sure that this child, God forbid something happens to them, that there's someone there to continue to raise the child, right? So that's the biggest concern I would have as it relates to grandparents, is acknowledging what their age is and then saying, okay, but Your Honor, while they're adopting them, this is their, let's say, uncle who's very involved in their life on a day-to-day basis, and he's going to step in as guardian, as the child will be willed to them, the guardianship, if God forbid something happens to the grandparent.
Awesome. Thank you so much, Elizabeth. And somebody then also asked in the chat if I could re-clarify the CLE code. Again, I'm really sorry. I'm on this tiny computer. It's my Surface Pro. I hate it. It's 240565, N as in Nancy, 240565 and 5654, N as in Nancy. It's in the chat twice. So scroll up, scroll down. It's in the chat twice. Either way, you'll get an email with that CLE code afterwards in 24 hours, or you can always email me. Elizabeth, folks in the chat are saying, great point, enjoyed this webinar. Folks on the Q&A are confirming they are wide awake, which I really appreciate. Thanks, Julie. And
it
I
makes
agree,
me feel better.
yeah. No, and we originally had, I think, like closer to 50 people on, and 38 are still here. They're definitely,
And I'm happy to
involved.
answer any questions. And a matter of fact, if I'm not mistaken, I think the front page or one of the pages even has like my information. Don't hesitate to reach out to me. Listen, there's nothing that's more important to me than everybody doing this properly. And I'm just not one of those attorneys that I want you to do it, but I want you to do it right. And I want you to know. And so reach out to me, please. I mean, I mentor a lot of people. There's actually people, I'm looking at the participants and I see 2 people that I've already mentored on here. So
Amazing.
I'm really, that's really cool. Please just don't go by yourself. Don't do it yourself. Okay. Yeah. And don't hesitate to reach out. And matter of fact, I'm listed. If you go through the Florida bar and you have adoption questions, they will actually direct you to me because I'm their representative for adoption.
Amazing. Well, everybody's saying very good webinar. And yes, I echo when we talked originally about this, that was another motivation of yours. If you're going to do adoption law, please do it the right way. The consequences are incredibly important. And I
The
think
consequences are so bad. I will tell you that in my 18 years of doing adoption work, I've never had a case like what I had these past couple months. I've never represented a birth parent to have their child returned to them because their child was basically stolen from them.
Yeah.
And I got to tell you, the emotional impact on the judge, myself, the attorneys involved, it was a level of emotion that I've never experienced in a courtroom before. And I think, and it was so hard because the adoptive parents were wonderful, I'm sure wonderful people. And we had to remove this child from them because their adoption entity acted so unethically. And it killed me that I was removing a child from people that I'm sure they would have been amazing parents, but that's not how we can do adoptions.
Yeah. I hear that. Well, thank you for sharing that. And thank you just for all of the great work that you do for our folks, going through the adoption process. I will touch base with you afterwards about the
Abs-
PowerPoint because I don't think I have a copy. If I do, it
I'm gonna
depends
send it
on
to you
time.
right now,
That would be great. I'll put it in a
but you don't want me to
PDF.
do too many things technology related at the same time?
And then you're going to get messed up here. Okay. So here's what we'll do. We'll end the webinar, and then I'll talk to you and touch base with you outside, Elizabeth. But thank you so much. And thank you all for attending. And thank you for your great questions. And I appreciate you all. And I'll see you at the next training. And Elizabeth, I look forward to any future collaboration. You are just stellar. It's amazing to learn.
Thanks, Alexis. Have a good one, love.
All right, everybody. See you. Happy Friday. See you. Enjoy the weekend.
Happy Friday, everybody.
Let's see.
Okay.